The facts of this case involve an incident in 2014 where New Mexico police officers shot at a woman, Roxanne Torres, as she was driving away from them. She brought a claim for damages against these officers, saying that they violated her civil rights. But if no seizure occurred, then there couldn't be any Fourth Amendment violation at all, so she would be left without a remedy for their use of force against her. There certainly are actual disagreements between Ms. Torres and the police officers in this case about what actually occurred during this incident. But the only thing the Supreme Court was deciding here was the threshold legal question of what counts as a seizure at all. The Fourth Amendment provides that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. When it comes to persons, there are two kinds of seizures that can occur. One is a seizure involving the police assertion of authority. We know from a previous Supreme Court case called California versus Hodari D. that if the police demand that someone surrender, but that person doesn't and runs away, no seizure has occurred for Fourth Amendment purposes. But the other kind of seizure of persons that can occur is the application of physical force to the suspect, even if no assertion of authority has been made by the police officers. And there is really the relevant question in this case. Does a seizure have to require that physical force bring the suspect under the police officer's control, or is the mere application of physical force enough to effect a seizure? Now, in the California versus Hodari D decision, which was written by Justice Scalia, the court said that the mere application of force, whether or not it was successful, was enough to effect a seizure for Fourth Amendment purposes. So you would think that would resolve the question in this case, but there was an argument made by the police officers that that statement was really just dicta. In other words, because the issue in Hodari D was about the police assertion of authority. It was about the other kind of seizure. The court's statement about physical force was merely dicta and therefore wasn't binding on the court. The majority opinion by Chief Justice Roberts didn't really squarely resolve this dispute because it said whether or not that counts as a holding or as dicta, we independently agree. The majority agreed with Ms. Torres that a seizure for Fourth Amendment purposes is effected when law enforcement officers apply physical force to a suspect with the intent to bring that suspect under control, whether or not that force is successful in bringing the suspect under control. I think the disagreement was about how to apply legal principles of textualism and originalism to the question at issue in this case. The majority cited relevant founding era authority saying that the term seizure in the Fourth Amendment incorporated the common law understanding of arrest. Justice Gorsuch, in dissent, argued that really we should be focusing first and foremost on the definition and meaning of the word seizure, and that the ordinary understanding of that term would require physically seizing someone and keeping them under your control, rather than turning to the common law understanding of arrest. So now, on remand, the lower courts will have to decide whether that use of force was reasonable under the Fourth Amendment. But we know, at the very least, that it does count as a seizure.